As we mentioned, two major decisions handed down by the Supreme Court. Want to get live now to the steps of the Supreme Court. And Shannon Breen's been reading through this. Two of them I want to talk about, Shannon. The first one has to do with a cell phone case in which it addressed the question whether or not police officers needed a search warrant before they could search your cell phone. How did they rule?
Right. Well, if you've been arrested, the court unanimously has decided that if a police officer wants to search a cell phone they find on you, they find in your car after you've been arrested or that car's been impounded, they have to get a warrant. Bottom line, the Chief Justice wrote this for the unanimous court, and he said, our answer to the question of what police must do before searching a cell phone seized incident to an arrest is accordingly simple. Get a warrant. So he says, and this was argued as well when they had arguments here at the case, that today's cell phones are different. You have all kinds of apps that can access your medical records, your bank records. There's all kinds of information that tells everywhere that you've been, who your contacts are. Now, the court acknowledges that's helpful information in fighting crime, and so it's important, and this is going to, basically put up an extra barrier for law enforcement. But the fact is we have the Fourth Amendment. It says no searches and seizures unreasonable without a warrant. And basically in the cell phone decisions, there were two cases. The court combined them. They say, police, if you arrest someone, you can't search that cell phone without a warrant. That's case number one. On to our second case.
Can I stop you there? Just what was the justices ruled what again? What was the number?
It was unanimous on the cell phone case.
Unanimous, okay. 9-0. Wow, nobody recused themselves, okay. The second case deals with a company that was trying to basically remake television. Now, what happened there, known as Aereo?
Well, the case is involving a company known as Aereo, and what they do is provide a service that essentially lets you watch live television programming via the internet. So if you're not in front of a TV, but maybe you're at your work computer, maybe you're traveling, Aereo has a delicate system of antennas that can tune into servers and pick up programming. Well, the network said, hey, this is our original programming. You can't just steal it and put it online and let people pay you to watch it on the internet. A lot at stake here, and it's a win for the networks and the television companies. Under the Copyright Act, it gives the owner of that original programming the exclusive right to perform the copyrighted work publicly. Well, what the court has decided, I believe it's 6-3 in this opinion, they've decided basically that what Aereo was doing was publicly performing copyrighted work that somebody else owned. So they've written their opinion, they've sent the case back down to the lower court, but basically we don't see a way that Aereo can win based on how this opinion was written. So the case technically is still alive, but basically a big loss for Aereo, a big win for those networks.
So that dealt with copyright. I mean, who were the dissenting judges on that? Who thought that you can go ahead and do that and take someone else's property?
It's interesting. Let me tell you here, so I'm accurate. It was written by Justice Scalia. He was joined by Justices Thomas and Alito. Interesting point, though. What Scalia said, if I can find it here, in his dissent was, he said, basically, I agree with what the court is doing. He said, I share the court's evident feeling that what Aereo is doing to the network's copyrighted programming ought not be allowed. So he's on board with them with the underlying principle, but he says, perhaps we need not distort the Copyright Act to forbid it. So he says, basically, the way they've interpreted the law wasn't correct, but he agrees with the underlying premise that what was happening here, basically Aereo shouldn't be allowed to do it. Bill?
Okay. Could that live another day?
You know, it goes back down to the lower courts for another round, but again, the way that the justices have written this, it's tough to see how Aereo could win, even with a fresh argument.
Great job, Shannon. Under pressure, too. Well done. Shannon Breen at the court. Thanks.